Welcome to the Osborne Morris and Morgan Solicitors podcast.
Well, welcome to the podcast. Today we're talking law, and it's great to have with me in the studio Emma and Angela from Osborne Morris and Morgan Solicitors. Hello, how are you doing today?
Good morning, Chris. This is Emma. Thank you so much for having us. It's great to be here.
How are you doing, Angela?
I'm really good. Thanks, Chris. Thanks.
Fantastic. So the reason you're here is because your firm has been going for over 40 years, and between you, you've had a lot of experience of dealing with various different areas that people might need some advice with. Could you just briefly summarise the different areas that your firm deals with, please?
Yes, absolutely. We deal with a wide range of legal matters. So conveyancing, wills and probate, court of protection, which is assisting clients who can't manage their own affairs, and litigation, so specifically medical negligence and personal injury claims.
Fantastic. And who do you have working with you? Who's on your team?
So we work in the litigation team. I'm the head of department there. And also we have a senior solicitor called David Turner, who specialises in medical negligence matters. He was a former senior partner of the firm, and he has a very long track record of successfully dealing with medical negligence matters. That's
fantastic. So that's a huge area, isn't it?
Yeah,
and I guess a lot of that comes with experience of knowing.
So you need to understand the medical background to matters. So
you must need a reasonable amount of medical knowledge as well to do that kind of a job, because it's kind of spanning law and medicine, which are two enormous areas of knowledge.
Absolutely. And we work with medical experts who give us guidance as to whether there has been a breach of duty by a treating doctor. But also the solicitor has to understand the medical issues involved.
And who are your other teammates?
So Emma here. Emma deals with medical negligence and personal injury claims, as do I. And we also have two other solicitors. So Ahmed Jarad, who is a newly qualified solicitor. He's been dealing with personal injury claims for a good few years, but he has a good number of years' experience of specifically road traffic accident claims. We also have Isabel Corbett, who has a background in court protection matters, and she has recently qualified into the team, so it's lovely to have her working with us. And we have our litigation assistant, Annie Lawrence, as well, who has worked at Osborne Morris and Morgan for about 33 years. So she really knows the ins and outs of the firm.
Yeah.
She supports us in the day-to-day running of the department.
Fantastic.
And liaising with clients as well.
That's great. It's great to have somebody like that who kind of holds the whole office together, and it's just like the linchpin of everything. And what's your personal background?
Yes, so I qualified as a solicitor in 2003. So 21 years, just over 21 years ago now. And I spent the first part of my career working in London. I dealt with a lot of personal injury claims there. I also worked on the second inquest into the New Cross fire, which some of your listeners may recall. Also, I dealt with claims to the Residential Institutions Redress Board in Ireland, which were claims for people that had suffered abuse as children in children's homes in Ireland.
That was a huge story on the news. I remember that.
Yes, yeah. And then more recently, I moved out of working in London to work at firms a bit close to home in Bedfordshire, and I was working on the infected blood public inquiry, which has been in the news a lot, still in the news. And
that's another one that's been dragging on for so long, and it's an absolute scandal that really needs to get resolved quickly.
Yeah, it really does. And then in the summer 2022, I joined Osborne Morris and Morgan and started heading up the litigation team there.
Fantastic. And you're enjoying it there?
Oh, really, really friendly firm, really nice. Yeah, it's great. We've got some really good work and lovely clients, and a great team of people to work with.
Do you find that when people come and see you, they're at a point in their life where obviously some things happened and they need legal help, and it can be quite a stressful time? And I guess when you go into a solicitor's and you walk through the door, the first thing that you're feeling nervous about is, am I going to get bombarded with legal jargon and kind of feel completely out of my depth here? But I guess you guys do as much as you can to make people feel relaxed and comfortable as they come through the door.
Absolutely. I think we've got a huge amount of experience behind us all. And I think that anyone coming to speak to us will be assured of a supportive, friendly face, there to listen, very much working with them to get them over a very difficult point in their life. fighting their corner in the best way that we possibly can, but hand-holding them all the way through the process at the same time.
Yeah, absolutely. And I guess, it's a comfortable environment. You can have a cup of coffee, sit down and just have a really friendly chat with you guys.
Definitely. We'll be open and honest, friendly listening ear, and give them the best advice that they're needing at that particular time. Yeah.
So do you find that people, when they come and see you, they've got a lot of worries, a lot of concerns, they need advice as much as they need?
Yes, just want to know where they stand, what they're entitled to, what the process looks like, and how long it's all going to take. So hopefully we'll be able to demystify those queries and concerns today in the conversation that we have with you.
Fantastic. Well, one of the things that I think would be quite useful to do is to give people some examples of the kind of thing that you deal with and how you've helped particular clients. So have you got any good examples of those?
We can tell you a bit about the types of cases we deal with. So we deal with, as Emma said, road traffic accidents. So that could be for people that are drivers, passengers in vehicles, cyclists, pedestrians, motorbike riders. We also deal with claims arising from accidents at work and accidents in public places, so quite a wide range of circumstances. And we tend to deal with claims involving significant injuries which have disrupted people's lives and probably impacted their ability to work, to care for themselves, and just generally their ability to go about their day-to-day lives as they wish. So really a traumatic incidents that people, when they come to us, they're in need of really a lot of practical help initially. It may be that they're not getting paid by their employer. They may have treatment needs that are not getting immediately addressed on the NHS. So it's rewarding to be able to help them as much as we can. If you've got a circumstance where it's clear that the other party's been at fault for a very serious accident and somebody's in need of financial assistance and treatment, then that's something we can start working on straight away.
Yeah, so I guess it's one of the most satisfying parts of your job is the human side and actually, being able to help somebody turn their life around and really get through the problems that they're facing at that time. Yeah,
we actually really do get to know people, don't we? Because we can be dealing with their claims for a number of years. You get to know them and their families and help support them as much as we can on the road to recovery.
Definitely. I think one of the most rewarding things is seeing them at the starting point, isn't it? And then getting to the end of the case and just, seeing the transformation and the difference, and hopefully the compensation that we've been able to fight for and achieve for them make a real difference for their future and what they're able to achieve in moving forward.
What would be a typical case that you deal with? What would be, is there a typical case?
It really varies so much. It can be people that have had an amputation, a brain injury, psychiatric injury, orthopaedic injuries, so very wide-ranging. But perhaps an example of a situation where we can make a difference. Thinking of cases that we've dealt with where people perhaps have lost a limb and have been provided with prosthetics on the NHS that aren't of the top quality and they may not be very comfortable for them. But if we've got a claim that we've bought and we've managed to secure an admission of liability on behalf of the other party, we can then agree with them that they will make a payment, what's called an interim payment of the compensation, to pay for private prosthetics to give an injured person that's in the very traumatic situation of having lost a limb the very best possible prosthetics that can be purchased to make such a difference to them.
Yeah, so that would make a huge difference, wouldn't it?
Enormous, and really of not just physically, but the impact that can have mentally as well. If somebody's in a situation where it's incredibly uncomfortable to even leave the house because of the discomfort they're experiencing with ill-fitting prosthetics, for example, that's going to have an impact on them mentally, that they can't get out and perhaps just go for a walk, go and see friends, go to the supermarket, just things that we will take for granted a lot of the time. So, it can make a real difference.
And for something like that, how difficult is it for your client to kind of go through that process? Is there a lot that they need to do in terms of like finding evidence and documentation and paperwork and stuff, or do you take care of some of that?
At the start of the process, we ask them to provide us with everything that they have, and then we can work with clients to get additional information we need. So, for example, documentation in relation to past earnings. We can provide them with a form of authority. We can write to employers to obtain that information. Medical records, the same situation. So we if it's information that clients don't have, we do the legwork to get that information. Yeah.
Oh, that's great. And how long does the whole process take? Because I guess some of these things can be quite lengthy.
It really depends on the circumstances of the particular case. So it depends if you've had an admission of liability early on by the other party, or if not, then we may need to look into the circumstances. Say if it's a road accident, we may need to obtain witness statements, police reports, CCTV, an accident reconstruction report. And if you need to go through the process of issuing court proceedings for a judge to determine who should be at fault, then that's obviously a lengthier process. And also it depends if you can agree the value of a claim with another party, how many medical reports are required.
Wow,
There's a lot involved. And we need to, in cases for injury claims, we need to know the long-term picture for the injured person. So in order to determine how much their claim should be worth, so will they be able to return to their pre-accident employment? Will they have long-term treatment needs? What will they be able to manage to do at home? How much support will they need in terms of care at home with mobility? So there's a lot to be taken into account. It's very difficult to give an estimate. I would say, gosh, on the cases we deal with, possibly somewhere between 3 and 6 years, which sounds like an awful lot, but don't forget we're dealing with high value cases, which are cases involving recovering substantial lost earnings for people if they're out of work for quite a time, treatment costs.
And every case is unique, so you appreciate, we can't, it's not a blanket across, it's every case is unique.
Yeah.
And once a case is settled, that's the end of the matter. So it's really important for us as the legal advisors to be satisfied and absolutely certain that we've got a clear prognosis and understanding of what the future looks like before we start the settlement negotiations and agree final payment out. Yeah,
absolutely. With these things, they can drag on for a very long time because, even look at the post office scandal that's been going on, and that's been going through the courts for forever, it seems, and there's still more process to be done. But I guess it's, depends on the circumstances, as you say. Like some things could be resolved a lot more quickly. And in terms of what it's going to cost people, is there any risk there?
So basically, it depends on the way that the claim would be funded. Some people have what's called legal expenses insurance under household insurance policies, and it may be that their insurer will fund their legal costs. If they don't have legal expenses insurance, we can look at offering people conditional fee agreements, which are not no-win, no-fee agreements. They're commonly known as, in cases that we take on that basis. We take out insurance to back those cases, which fund the expenses throughout the claim, so people don't have to put their hand in their own pocket to fund things like medical reports and court fees.
Yeah.
So it may be under no-win, no-fee agreements that people would have to make a contribution towards their legal costs, because the way that these things have changed in the last 10 to 15 years. But it's not something that when they come and see a solicitor, they've got to write a big check out to us. The principle is that if you win a claim for compensation, the other party will pay the majority of your legal costs.
I think that's going to be something that a lot of people are worried about, and kind of feeling like as soon as you walk through the door of a solicitor, the clock's ticking and suddenly money's being charged. Do you offer free consultations to people?
Yes, absolutely. Yeah. We are very approachable. People can either give us a call or we can arrange to see people and to talk through their options.
And we speak to many clients on a daily basis, for a period of time where, and often the case isn't always taken on for various reasons. So there is no cost for those sorts of conversations and inquiries. Want to be supportive and hand-holding for whoever decides to approach us and trust us with their legal problems.
That's good. And I think that makes such a difference, that if you are friendly, if you're smiling, if it's, you're not wearing I had a solicitor who wore a bow tie, and I found that very, very intimidating. So I think if you create that environment where people feel relaxed, then there's a lot less stress and a lot less pressure. And I think also some people worry that they might have to stand up in court and give evidence, and there's going to be really difficult situations they have to deal with. Is that always the case?
Not always the case. I'd say, in my experience, that the majority of cases settle out of court, but it is always a last resort if it's not possible to reach agreement with the party that you're bringing a claim against. either on the value of your claim or who's at fault for an accident. And if somebody did find themselves in a situation where they did need to go to court, then of course we would be there to support them along the way. It would be that a barrister would represent them at court, and we would go through the evidence that they would need to give beforehand, so they would be well prepared and well supported.
And I think people have a certain preconception of what it's going to be like in court based on what they've seen on TV dramas and things, and it's not always exactly like that, is it?
No, I would, to some degree, as it probably is, but
yeah, we had a court hearing only in the summer up at the Royal Courts of Justice, which was hugely exciting for those legal advisors, obviously less so for our client. But yes, I mean, I guess there is an element of old school, and the barristers were wearing wigs and gowns and things. But and it is a daunting process. We absolutely understand that. And as Angela said, lots of work would be done with the client before we got to that stage. And often it's not necessary to go to court. We can negotiate settlements, but there would be the support all the way throughout the trial and beyond to make the process as easy as possible for the client. I
think for me it would be that fear that you're going to have some kind of cross-examining solicitor coming at you. I put it to you, sir. And it's terrifying. And you crumble like you're on EastEnders, and suddenly, even though you're being honest, it's still very, very scary.
But I think clients that find themselves in a situation where they've been seriously injured, they may have lost their ability to work, they're reliant on friends and family for care, they really do feel that they want to have justice. And if they perhaps have a defendant who is denying liability or not offering them sufficient compensation to compensate them, then I think often they have a strong sense of wanting to kind of do as much as they can to get back to the position they were in. So I think a lot of our clients are quite determined, aren't they?
Absolutely, yeah, and rightly so, because they've been put in a situation that wasn't their fault, and the consequences are often enormous and very, very significant.
Absolutely. So hopefully, by the time you've been through that whole process, things get resolved, and then I guess the compensation just gets paid straight into your bank account. Do you have to pay tax on compensation?
No, you don't have to pay tax on compensation. In some circumstances, clients may need what's called a personal injury trust, which can protect it from impacting means-tested benefits. It's a legal way of preventing compensation impacting your entitlement to means-tested benefits. But we have a team that can deal with that and provide advice for clients where necessary.
I think a lot of people are going to be wondering how compensation is calculated when you make a claim. What kind of factors come into force? Is it based on how good your solicitor is, how much they can get out of the other client for you, or is there some kind of way of calculating it so it's all done fairly?
It should all be done fairly, Chris. It's quite scientific, and it depends on a number of factors. Compensations is split into two types of damages. Firstly, general damages, and that's the sum compensated to the injured party for the non-economic losses suffered by them, and that includes sort of pain and suffering, loss of amenity, enjoyment of life, and emotional distress. And it should take into account all things that the injured party might have been able to do before the accident, and which might no longer be possible or severely curtailed. So some examples of that include the nature and severity of the injuries, recovery and rehabilitation time, the extent of any long-term disability suffered and the effect that this will have on an injured party's life, the age and pre-accident health of the injured party, and any psychological damage caused by the injury. The way that we calculate general damages is to take on board all those sort of recommendations and considerations of the independent medical reports that we've obtained as part of the case. We consider those alongside previous case law that is available for us to be able to access, and look at what other awards have been given in the past to individuals, alongside some guidelines that are set by the court. They have various brackets for various different injuries, and then a combination of those factors enables us to get a broad ballpark as to what the compensation for general damages might be available to that particular injured party.
Okay, that's very interesting. So I think a lot of people might come to you and say, I've just seen on the news that so-and-so has got this much compensation for hurting his foot and he's a footballer. And it doesn't necessarily mean that has any relevance to your claim, even though it might be for the same sort of injury. Exactly.
And there are some additional damages called special damages that we also take into account when evaluating an individual's case, and that's for financial losses that have been incurred as a result of the accident. So typically, again, some examples for you: any personal possessions or items of clothing that might have been damaged or lost as a result of the accident. It's inevitable, particularly in cases involving serious injuries, that people will need to be off work for a period of time, or indefinitely in some cases, sadly.
Yeah.
So, we'll look at the loss of earnings to include being away from work, any potential future loss of earnings arising for their incapacity to be able to return, and indeed the impact on any party's career progressions. Those are all sorts of things that we would take into account and obviously contact employers for advice and information on. You'll appreciate that in any sort of injury case there's going to be the involvement of medical professionals, be that physiotherapists, osteopaths. So medication costs, prescription costs, treatment costs are all the sorts of things that we will be able to look to recover as part of the case. That might be inpatient care, surgery costs and ongoing rehabilitation. So those are all things that we would factor into any case. Cost of services provided by professional carers, but also family and friends. You obviously don't expect to pay family and friends to look after you, but those are the sorts of things that we would be able to claim for. Them doing anything over and beyond what would ordinarily be expected as part of their day-to-day living with you. The travelling costs of going backwards and forwards to medical professionals quickly mounts up. Those are all things that we would I'd say add to a schedule that we would collate and incorporate into the case. Accommodation costs is something else that we would look at. Angela's mentioned, amputation, and sometimes it might mean that a property will have to be adapted, or even in some cases, the client will have to move because of the disabilities that have come about. So it might be that we need to put in a wet room or a downstairs bathroom because they're not able to access, the bathroom upstairs. Those are all things that we would look to consider whether would be recoverable.
And I guess if you're in that situation, you're going to need those adaptations made to your living situation straight away, because you can't be hanging around for years waiting for this to go through the courts.
You would hope so.
You would hope
so. Ideally sooner rather than later, but obviously much depends on the position of the other party. Are they admitting liability, or are they disputing it? So hopefully it would be yes, we accept responsibility, and then we can start communication with the other party. And get some sort of interim payment to allow those costings and adaptations to be done. But it depends on a case by case basis. Other sort of incidental costs, car parking charges, online supermarket charges. It might be that you would ordinarily go shopping week by week, but obviously if you're incapacitated and you're stuck at home, you're going to have to sort of resort to online shopping. So whilst there might be sort of £5 here and there, it's quite amazing how quickly
all adds
they all
up.
mount up.
All adds up, and especially delivery charges from supermarkets.
Exactly.
If you're needing to do that a couple of times a week, that can be quite a significant amount of money.
Absolutely, yeah. So in all these cases, it's really important that we provide evidence of loss and expenses. So we would absolutely recommend any client that we speak to keeping sort of a docket or a folder of all these receipts, invoices, medical bills, pay slips, because it really gives weight to the case, and that loss has been incurred. So a bit of a practical point there.
Do you have to keep the original receipts? Because I would find it easier just to take photos on my phone and save them all in a folder, or for legal reasons, do you need the original paper ones?
I think original would be better, but I think as long as we've got something to be able to substantiate a particular loss, it's better than nothing. So if we put a claim in and we haven't got anything to support it with, it's much harder to argue. But if we've got some proof of that loss, then it's far easier to.
Could you do it from bank statements, credit card bills?
Yes, absolutely. We often scour those sorts of documents in the course of proving a particular loss. I should say that an injured party has to mitigate their loss, and by that I mean it's important that all those losses claims are reasonable. So it's not fair that you go out and live in a 5-star hotel because you can't, you need somebody to look after you. So it's important that you be mindful of the loss and to ensure its recoverability. And once we have that information to hand, we prepare a document called a schedule of loss, and so everything goes into one major document that's obviously updated and amended as the case goes on, and then ultimately that's served on the other party with all their supporting evidence and receipts to be able to prove those financial losses.
Because you've got to make sure that they have an opportunity to prepare their case in court as well. So you
absolutely
have to have everything ready at the point that you're telling them that they need to go to court. And how far ahead of the court date is that normally? Because I guess they need to have time to prepare their defence. It
does. I think often we try and work very closely with the other party and have a sort of joined up collaborative approach in the best way that we possibly can. I think there's a time and place for being argumentative, but let's work together for the good of the client to see a resolution to the particular case. So I think as and when there's sort of critical points in a case that it seems appropriate to share that information, we will do so. It just depends on whether proceedings at court have been issued and we've got a timetable that we're having to work towards, or whether we're before that stage and we're sort of working towards an end goal before the need to issue proceedings becomes necessary.
Do you find that you're working against the same solicitors quite often, and you get to know each other, and you can have kind of conversations with them to make sure that it's all done as amicably as possible?
Not always, actually. Sometimes you come across the same person, but it depends really. No, not particularly.
Because I guess some of these could be against big national companies, and they have solicitors that could be based anywhere in the country. It's not always going to be another local firm that you know socially.
Absolutely.
Yeah.
And they frequently are. Often insurance companies for car companies are, firms based up in the north, Manchester way. And so, yes, you're just talking to them on the phone rather than ever getting a chance to meet them face to face.
Do you find it frustrating sometimes how long it takes other solicitors to get back to you to answer questions? Because that's the main bugbear that I've had with solicitors in the past, has been just when they're incredibly slow. This is mainly with, I guess, when you're buying houses and things like that, and it just feels like everything seems to take a very, very, very long time. Do you have this with the other side as well, kind of trying to get answers to questions?
I wouldn't say so recently, no. I'd say that things do work in a good manner.
Oh, that's good.
Yeah. It's all
Is it different with this kind of area then to conveyancing, where things can be done a little bit more quickly, or is it just my experience
I think it's your experience from the sounds of it.
I also think in conveyancing, you've got more than one other party. You've got sort of multiple parties involved, and you're reliant on their timescales, working with yours. So I think that's often where the complication comes. I think that as a general rule, it's I'm seeing, and I think your experience is that people are keen to see a resolution. They understand the impact that this litigation has on a client. It is hugely daunting, isn't it? It's very stressful often. It's our day, it's day and day for us, but actually for a client, hopefully they'll never go anything like this again, and it takes over their life and their thinking. So I think the defendants have recently been more open to being more proactive and trying to work together to see a resolution.
And I would say that there are protocols as well that parties need to adhere to. So if we initiate a claim and send a letter of claim, then there are time periods for response and for investigation, so acknowledgement, and then a final response with a decision as to whether or not a defendant's going to admit liability or not, with an explanation and disclosure of documents. So they can't just let a matter drag out forevermore. We can make applications to court. If a party is not going to respond and just give us the silent treatment, we can apply to court for what's called pre-action disclosure, for disclosure of any documents that are of relevance to an accident, so we can move matters forward. It wouldn't be that if somebody didn't respond to us, that just nothing will happen and we'd say to a client, sorry, they haven't responded, we can't help. There are things we can do. We can force steps to be taken.
Oh, that's good. And you were saying about the 3-year kind of cut-off to start making a claim. If you do one, is that 3 years until you're actually going to court, or is that 3 years until you've actually begun the process of saying that you're going to do something about it? So is there a time limit to kind of get everything together and go to court, or once you've started the process, you've got a little bit more time to kind of get everything ready?
So the 3 years is the time that you need to lodge what's called a claim form with the court. So that formally starts court proceedings, but that's not the date of trial, because what happens once you issue court proceedings is that the court then takes over the management of the case, and they will have an initial hearing where they set a timetable for what's going to happen with the remainder of the claim, and each party will get an opportunity to make representations to the judge as to the circumstances of the case, what further evidence is required, what the issues in dispute are, whether it's both liability and the value of the claim, and then the judge, upon hearing the representations of the legal representatives, will give a timetable for the steps that need to be taken until trial, and then if possible they'll set a period for trial to take place and determine how long that trial will be. But if it's too soon because perhaps an injured person hasn't recovered sufficiently for trial to take place, or it may be that that it's not possible just logistically for a trial to take place, then they'll make provision for a further hearing to take place in the future where a trial would be set down.
That's very reassuring, actually, because I think once you've made that phone call and you've got the ball rolling, then you can take your time a little bit more, as long as you know that you've actually started the process.
Yeah, absolutely. It is quite structured. I think that's something I like about the job that we do. So you get people that are in a very traumatic situation, but once they come to us, we can help them with starting the process, and then there is a structure to it and time limits. So it's good to be able to say to people, right, we can start this off. We know that we're going to get an acknowledgement with this, or we should get an acknowledgement with this within this period of time, and we should get a response with a decision as to the position of the other party to your claim. And if they're going to deny responsibility, they've got to provide us with an explanation and with documentation in support of that denial. So it's good to be able to give clients who are in the difficult situations they're in a bit of structure and reassurance that it's not just going to, we'll start this off, but who knows, we'll wait and see if we get a response. That's not the case. So.
And I think we were just keen to stress to the listeners today that, if they find themselves or know somebody who finds themselves in the unfortunate situation of having an accident, wherever that might be, just to keep a diary, because I think that it's really important just to sort of keep that to hand, to be able to just jot down the events that happened immediately after the accident, what sort of treatment they're having and how often that is, what their physical and psychological symptoms might be, and what sort of help they're getting from friends and family, because that will be crucial information for their legal advisors, will form part of their witness statements. Now, I can't remember what I was doing last month, let alone a sort of 12 months later, 12 months ago, which is often, the case sometimes when these things are prepared. So that sort of practical involvement would be really helpful for their legal advisors and for them. But also just to take some photographs. And I personally think it's really important to bring the individual to life. I think if you're sending documents and reports to another party, they're just reading a piece of paper. But actually, if we can bring the injured party to life and we can show firsthand the severity of the injuries and what that's meant for the client, it makes it much more hard-hitting, I feel. So I mean, I don't want to be too gruesome, but but take some photographs, particularly if there's bruising involved, because it gets worse before it gets better.
So kind of appealing to their conscience,
yes,
I guess,
yeah.
And it's kind of saying, look, this has happened.
Yeah.
This isn't just a dry bit of paper with a load of text on it.
Yeah.
Here's a picture. This is the person. This is the victim impact of what's happened.
This is reality of what's happened, and this is what it looks like. Yeah.
Fantastic. So, what would your advice be to somebody that's listening to this and is thinking, there is an issue that I have at the moment. I probably should go and see a solicitor and get this sorted out, but I think people procrastinate a lot, don't they? And they put things off, like going to the dentist and doing things that they find scary and difficult. And I guess you've just got to get the process started, haven't you? Is there like a time limit to making claims?
Yes, there is. And I think we'd say that the sooner you talk to somebody, us or somebody else, that the better, because of the need to try and sort of retain evidence or get information that sort of impacts on what happened and how. That's really, really important. Key takeaway is that there's a 3-year time limit in which to issue proceedings at court post-accident. So, that time can race by, and if you've been sitting on it sort of 6-12 months, then our ability to investigate things is severely curtailed. There are some exceptions to that. So if you're a child when an accident happens, you've got 3 years from the date of your 18th birthday to which to bring a claim. And if you haven't got what's called capacity, then limitation doesn't apply at all. So that's indefinite.
Wow. So have you had some cases that go back quite a long time? If it's somebody that's just turned 18 or obviously, for the sake of the client, we try and get the case pushed ahead as speedily and as possibly and effectively as we can. Often in a case involving children, not only have they necessarily sustained serious injuries, there's a need for them to sort of grow up and develop in any event, so we need time to allow that to happen. So unfortunately there are a couple of cases where they have been going on for longer than perhaps 3 to 6 years that Angela suggested, but there's been reasons for that. So for example, if there was an accident and you'd had some kind of head injury without realising how bad it was, and then 4 years later suddenly you've got a blood clot in your brain that could have been caused by the accident, you can go back more than 3 years if there's a reasonable reason why you didn't realise that you had a claim before that.
I think if it's in the case of a child, I guess if it's an adult, that should happen. There's something called date of knowledge. So if something comes to light later that you hadn't appreciated beforehand, then yes, that's another area that we can explore. Obviously, very case by case specific and involves sort of careful review and consideration of medical records.
That's great though, and that's why you're experts at this kind of thing, because you can go in and say, this is my situation, and once you know all the facts, then you can give your informed advice on what your options are and what you can and can't do.
Yeah.
So, but until you've had that conversation, then you don't know. So you just got to get the ball rolling, really.
Pick the phone up. We'd be delighted to have the conversation. Yeah.
So people can just call you. You can give advice over the phone, or is it better that they come in?
It depends, I think, ultimately on the severity of the circumstances. But certainly an initial call just to sort of fact find, get some information, understand a little bit more about the effects of the accident, how it's happened, and the long-term impact would all be things that we would be discussing with any client that might contact us. And then depending on that conversation, we would invite them in, or we go and see them at home. In some cases, obviously, clients are severely incapacitated. We frequently have gone to see clients in hospital where they're recovering, or even at home. So those are all considerations and conversations we'd be very happy to have.
I think probably just after that first phone conversation, you feel a lot better. You feel like a load has been lifted off your mind, because you've had a bit of empathy over the phone and a friendly voice to talk to, and somebody that's understands what you're going through and can actually give you some courses of action and some solutions to your problems, because you could talk to whoever you like, friends and family, but they're not going to be able to solve your problems if they don't have that legal expertise.
Yeah, a bit of clarification as to where you stand and whether we think you have a claim with sufficient prospects to take forward.
So do you sometimes get phone calls and it's completely takes you off guard and you think, wow, I can't imagine what it must be like to go through what that person has gone through, and I really want to do whatever I can to help them, because that's an awful situation that they're in?
Yeah, I mean, we're only human, and sometimes we do hear some really shocking stories of really traumatic incidents that people have been through. So yeah, if we're in a position to help them, we certainly will.
Yeah, so it must be quite a rewarding job when you can
really
get a good
is.
outcome for your clients.
It so
really
is, yeah, because they become a friend, a social worker, a counsellor, a legal advisor, where sort of a combination of all sorts of hats, at one time. So to see the transformation and hopefully the difference that we've been able to make with their recovery, perhaps by arranging for private medical treatment or rehabilitation, which has made such a difference to their recovery. It's meant they perhaps got better quicker than having to sort of rely on the NHS, which is brilliant, but obviously it comes with challenges. It is hugely satisfying, isn't it?
And
really just
is.
seeing them on their onward journey and thinking, well, we've played a small part in them getting there.
Yeah.
That's fantastic. So if people would like to get in touch with you, what's the best way to do that?
I think probably by telephone, direct. Great to speak to clients straight off. That would be wonderful. We both have emails, addresses. So yeah, whatever works best for the clients.
Fantastic. We can put all those contact details in the description of the podcast. So if you're watching or listening to this, then you can get in touch. But thank you so much for your time. And one final word of advice for somebody that is considering picking up the telephone and they just need a final little bit of encouragement to take that step.
Absolutely. Do give us a call at Osborne Morris and Morgan, and we'd be more than happy to talk through your situation and to see if we can help you. I'd say that we are friendly and approachable. So we'd be delighted to hear from you.
That's wonderful. Thank you so much. You've definitely come across as very friendly and approachable. So
Good.
I'm sure lots of people will be getting in touch. But thank you so much for your time today.
Great. Thanks, Chris.
Thank you.